And then the man in the middle, often the swing vote, Potter Stewart, the author of Pell and Saxby. When the case came up for argument, two justices were not participating. Justice, let me go back here. Justice Blackmun was, he had just had prostate surgery, so he wasn't participating in the case. And Thurgood Marshall recused himself, as he routinely did in cases in which the NAACP was a party. He had been general counsel for the NAACP back in the late 30s and 40s and early 50s, and he routinely took himself off any case involving any part of the NAACP as a party. Nick? No, they don't come back to break the tie. If one's out and they split 4-4, the result is the decision of the lower court stands. And there's no decision of the Supreme Court. But in this case, you got 7, not 6. And so my decision to include the NAACP branches as parties backfired because we lost what was a likely favorable vote when Marshall took himself off the case. So here we are in the Supreme Court, and the sheriff, having lost in the lower court, his lawyer goes first. His lawyer was a career civil servant, county counsel Calvin Booty, from Alameda County. Sonia? Marshall? He didn't participate at all. He was not in the courtroom during argument. He didn't participate in the deliberation. He was out of the case altogether. That question? No? And Booty was a very, very good lawyer. He's retired now. It was his first argument in the Supreme Court, and he was pretty nervous. So give him a break while he stands up and organizes his papers. It takes quite a while to do that. Let me see if I can get the audio to work. So Berger calls the case.
Hutchins against station KQED.
This is my edited version of the argument, so you don't get the whole thing. There's a couple of clumsy edits. So I hope you can get it. Anyway, Booty's up there shuffling his fingers.
Mr. Booty, you may proceed when you're ready.
Thank you, Your Honor. Mr. Chief Justice, and may it please the Court. The question presented in this case is, must the sheriff give greater access to his county jail facility to the media than he gives to the public? The purpose of the access in this case is to gather information. The district court in this case required a certain access be given to the media. There was no requirement that similar access be given to the public, and there was no determination by the district court that the public access was inadequate in any way. The required media access is, as I say, greater than the sheriff gives to the public. I'd like to discuss briefly with the Court what that public access is. First of all, it is mail, access by mail. There's no censorship. Letters are not read. They are subject to inspection only.
Can I interrupt with one question? Isn't the first question whether there was a violation of law that entitled any remedy, which requires an examination of the situation at the time the lawsuit was brought? Shouldn't you tell us what kind of access there was when the proceeding started?
Yes, Your Honor. All of the accesses that I'm discussing, except for the public tours, had in fact started when the proceeding started. So I will answer Your Honor's question in that way. The mail was there at the time the proceeding started. As I say, it was, if the inmate lacked cash to pay for stamps or postage or anything like that, that was provided. Secondly, at the time the proceeding started and after, there is visiting. Ample visiting is unquestioned example. There's no categories of persons who may visit. They need not be members of the family or anything else. Anyone, including a reporter, could visit. There are some restrictions on those who have been in prison or those who are under 18. The prison restriction stems from provisions in the California Penal Code. Again, at the time the proceeding started, there was access by telephone. For those who were in the maximum security facility, there was telephone access on a collect basis to anyone. The phone lines did not go through the sheriff's department in any way. They went right to the telephone company. So there was no monitoring, no capacity for us to find out who was called, what was said, nothing. Totally open telephones. Other than in the maximum security facility, telephone access was through the correctional services officers. Again, Mr. Justice Stevens, at the time the proceeding started, there were interviews with pretrial detainees available. Those could be done, in fact, they would have been done typically off the premises. Those could have been photographed, tape recorded. They would be private. No one from the sheriff's department would be there. The requirement there is that consent previously be obtained from the inmate himself, from his counsel, from the district attorney, and from the court having jurisdiction over the trial. What was not present at the time the proceedings commenced were the tours.
What he's doing here is what government frequently does in First Amendment cases, which is point out that there are alternative ways of getting the information out, alternative avenues for the speech to take place. The one that is being challenged is not the only way that information can be conveyed to the public. So he's emphasizing that information about the jail can reach the public through mail, through the telephone, and through visiting, and you don't need to open up the jail to reporters for the public to find out what's going on in the jail. And he says what wasn't there, all that was happening before the suit was filed. What wasn't there was the tours. And then that raises the question in Justice Powell's mind. He has a very soft-spoken voice, but he's concerned that the tours won't do the trick. So here's his question.
Did one of the briefs on the record state opinion that they were?
They became, the first 6 months of the tours became booked very quickly, quite possibly before the end of July. The first tour was on July 14, 1975, and probably before I don't remember, my recollection, Your Honor, is that before the end of July the tours had been booked.
And so if there were some occurrence in the jail that might have been of public interest, there would be no way for a representative of the media to get into the jail once he'd been signed up several weeks in advance?
That's correct. He could not have gone on one of the tours. That, of course, is not the only means of access, Your Honor. Had there been an occurrence in the jail, indeed before the tours ever started, the media can and does have alternate means of finding out what's going on. By means of interviews, I have not completed the access that is now and was then available to the media.
Booty, you've been outlined.
This is Rehnquist asking a question here, which is a way, asking the questions is one way for the justices on the court to talk to their fellow justices. And bring out things that may affect their fellow justices' points of view. And Rehnquist asked a completely softball question, expecting an obvious, reasonable answer. And Booty is too honest to take the bait, and instead says what the truth is. Anyway, here's Rehnquist's question.
What I gather are general policies of the sheriff's office. Are these designed to cover the situation supposing a riot had broken out in the jail or some event of particular newsworthiness? Would these regulations have necessarily governed press or public access under those circumstances?
Yes, it would. There's nothing in the record in any case, Your Honor, to indicate any alternative means to these. And as I say, I'm not finished, but this access package taken as a whole is the entire package. That completes, Your Honors, the access that exists. The complaint of KQED with respect to this is that there is no random interviews on the tours, that no inmates are on view for their cameras in cells or barracks or eating for televising, and that there is no access on demand for their equipment. As I have just indicated, there is access with their equipment on a scheduled basis, but not on demand. The district court did not make any finding of any intention to conceal conditions in the jail. But nevertheless, the district court made its injunction, which requires the sheriff to allow what it called full and accurate news coverage, and specifically required the sheriff to permit random interviews on the tours and to permit the use of cameras and tapes, and plainly not on the scheduled tour, but on a demand tour. The only exception stated in the district court's memorandum and injunction was that when tensions in fact existed, the sheriff would put a stop to the access. In fact, the district court virtually invited litigation on the point because it says if anybody thinks there really isn't tension, they can come in and we'll have a hearing on that. So what the district court did then is it balanced the asserted media needs against the sheriff's public access program. There was no balancing by the district court of the public's rights in any way. The district court did not address the public rights in any way.
When you say the public right, are you talking?
Oh dear. Oh dear. That's disastrous.
Motions against
Starts all over.
station KQED.
Let's see if I can get somewhere near where we are.
Preliminary injunctive relief to live with a special tour.
With respect to this is that there is no random interviews on the tours, that no inmates are on view for their cameras in cells or barracks or eating for televising, and that there is no access on demand for their equipment. As I have just indicated, there is access with their equipment on a scheduled basis, but not on demand. The district court did not make any finding of any intention to conceal conditions in the jail. But nevertheless, the district court made its injunction, which requires the sheriff to allow what it called full and accurate news coverage, and specifically required the sheriff to permit random interviews on the tours and to permit the use of cameras and tapes, and plainly not on the scheduled tour, but on a demand tour. The only exception stated in the district court's memorandum and injunction was that when tensions in fact existed, the sheriff would put a stop to the access. In fact, the district court virtually invited litigation on the point because it says if anybody thinks there really isn't tension, they can come in and we'll have a hearing on that. So what the district court did then is it balanced the asserted media needs against the sheriff's public access program. There was no balancing by the district court of the public's rights in any way. The district court did not address the public rights in any way.
When you say the public right, are you talking about some term that has meaning in constitutional law?
Yes, I think I am. I think the public does have some rights of access.
Is the sheriff of Alameda County an elected official?
Yes, Your Honor, he is.
And I presume if the public in Alameda County thought they weren't getting enough access, they could vote against him in the next election.
No question about it.
And what other right of access does the public have?
How does one...
I mean, under the decided cases of this court.
Well, that's...
Under the Constitution of the United States.
As interpreted by this court, which may be a different...
It's not entirely clear. In the Pell case, what the court did, as I read it in any case, is the court found that there was no intention to conceal any conditions. The court found that there was public access, and that was enough. Those two factors. There was plainly nothing being swept under the rug, nothing being hidden. The court determined that the public access was there adequate. That was the statement of the court. Now, I appreciate, and the reason I hesitate, Mr. Justice Rehnquist, I appreciate that the public access in that case was not, strictly speaking, an issue, just as it was not placed an issue here.
Wasn't Pell really a decision that said whatever the public access is, the media access need be no greater?
Indeed, that's exactly what the court said. But I don't read the decision as saying that means necessarily that the public access is zero. That's not resolved in any decision of this court that I'm aware of. It wasn't placed an issue in that case. That's my point.
But more specifically, Mr. Bill, you don't seriously contend that the whole problem could be solved by having zero access to public and press both. Is that
Certainly not.
Why don't you?
Well, that isn't...
It's a perfectly logical position to take.
Well, it is...
It's a correct position.
Yes, it is a logical position, Your Honors, but it isn't our position. There's no... I'm not convinced, and I am considering the body that I'm speaking to, I'm not convinced that that's what the court held in Pell.
What the court held in Pell was, and I understood it in writing it, was that the press had no right of access superior to that of the general public.
Absolutely. No question about it.
Didn't hold and didn't deal with whether or not the general public had any right whatsoever as under the Constitution, the First and 14th Amendment, or any other provisions of that document.
Well, that's exactly my position, too. You're right. It wasn't...
Well, that was the gist of the sheriff's argument. It's not a good sign, is it, that Stewart, the swing vote, the guy that's got to be convinced in this case, jumps in and says, why don't you take the position that access can be zero? It's perfectly logical. How are we going to deal with that? Well, the custom in the Supreme Court is you stand up and you say, Mr. Chief Justice, and may it please the court, and then you get to begin your argument, lay out what the issue is or what some key point is and so on before the questioning starts. But the court was in no mood to wait, and Berger interrupts my opening salvo.
Mr. Turner?
Mr. Chief Justice,
What
may
do
I
you have
please
to say
point?
about
Well, first off,
an individual who walks in on the day when the press has a scheduled tour and says, I have a camera, I'm an amateur photographer, and I want to go along. Do you think the sheriff can exclude that private citizen?
First off, I'd like to correct the state of the evidence. The sheriff has never toured for the press. There's nothing in the record to support it. All he said when it became clear at the evidentiary hearing in this case is that he would be willing, if the court was going to grant preliminary injunctive relief, to live with a special tour for the press in which they could bring their cameras and do their business in that way. He has never implemented that offer. And in context, that offer was only to be carried out if the district court was going to order him to do anything more than he was otherwise willing to do.
Do you think as a matter of prison or jail administration, the director or sheriff could say, it's more convenient to keep these two categories separate? That is, we'll have general public visitation on the first Monday in every month, and we'll have media representatives on the second Monday of every month.
I think it is permissible
for an
administrator of a jail or a prison
any
to
constitutional question involved in that kind of a decision? Or is that just routine administration of the institution?
A constitutional question arises when, as in this case, the sheriff limits access by reporters either to 0, as before this case was filed, or to these antiseptic guided tours that he initiated right after we filed suit. There's a constitutional issue.
Well, if he gives the media precisely and exactly the same access as the public, do you think there's any constitutional problem involved?
I do if that access is 0, or if the access is not reasonably sufficient to prevent concealment of conditions in the jail. Then we would have a situation, as they have in South Africa, where the press is effectively precluded from reporting on jail and prison conditions.
What part of the Constitution do you draw on to say that there is a right of access to take pictures and do these things?
Well, this is a First Amendment case. I think it would trivialize the First Amendment to say that it requires specific things like a particular number of days a week, or photographs, or random interviews as opposed to full interviews with individuals and so on. I don't think that's what the First Amendment does. What the First Amendment does is prohibit a government official from unjustifiably interfering with the acquisition of information for publication. And that's what this case is about.
Well, when you say unjustifiably interfering with acquisition of information for publication, then it is a justiciable question in every case whether, for instance, the Supreme Court of the United States excludes the press from its conferences, or whether the Federal Aviation Administration excludes the press from its executive sessions.
Well, I don't know about just justiciable.
Well, under your test, at any rate, it's something that's subject to constitutional inquiry by a court that can decide constitutional questions, whether the decision of any governmental official to exclude the press from any part of the public domain is, under his control, is, quote, justifiable.
This is the floodgates point, that the court, Rehnquist, is concerned that if they recognize a First Amendment right of access to government facilities or information, there's no limiting principle to that. There's no point at which the government official can say no without getting sued. And the court is fearful that saying there's a right of access means that every time a government bureaucrat says, no, you can't come in, no, I'm not going to answer that, no, you can't see that, that creates a First Amendment lawsuit that the government will have to defend against. So how do you answer that? Well, there has to be some limiting principle, and that's what we struggled to.
Yes, that's our position. Our position, of course, is not that the press is entitled to sit in on conferences of this court, any administrative agency, and so on.
Only because that's a justifiable decision on the part.
Yes, and the information has some claim to confidentiality.
But in each case, you could go into the United States District Court, whatever district you want to, and under 1331, argue a constitutional question as to whether or not the decision of the particular agency was justifiable.
Theoretically, yes, but in fact, there aren't any other agencies that we're aware of that treats information the way the sheriff does. The evidence in this case shows that the jails and prisons in the area are completely open to the press, and they may enter and go into the maximum security sections, talk with prisoners, interview prisoners, take pictures, whatever they want to do. Those are the institutions where one would assume public access is rather limited.
Well,
justifiably so.
Let's suppose the president decides to have cabinet meetings open to the media with television and all the other incidents. Does that mean that the courts have to open their conferences because someone else does it?
No, of course not.
Well, then what significance is it that some other prisons in this area have different practice?
Because it shows how unjustifiable the sheriff's practice is. The only feasible way that the public at large will know what's going on in this jail is if reporters are allowed in. A handful of people can go on the tours, but reporters, acting as agent for the public at large, the eyes and ears of the public at large, can go in and without any disruption to jail routine, because it's done routinely in all of the other jails and prisons in the area, can meet this public need without interfering with any valid purpose of the sheriff.
What would you say?
Now, the sheriff, in answering why shouldn't reporters be allowed to do their job, the same job done in other jails and prisons in the area, points to the court's decisions in Pell and Saxby. And his core position is that all he needs to do is provide equality of access. Not access, but equality is the way he reads those decisions.
How do you read them?
We think that the whole assumption of the Pell and Saxby decisions is that there be reasonably sufficient access to prevent concealment of conditions. If there is that, then equality is fine. We don't claim any superior rights for the press.
Well, you do claim, I suppose, you can reasonably claim that even though the right of access of the communications media is no greater than that of the general public, that perhaps because of the technical needs of the communications media, the equality needs to be provided in a different kind of way. In other words, let's say that there's a right under the existing rules and regulations, the public can go through the certain rooms of the White House within certain hours every day. Well, the press couldn't set up its television cameras then and there and interfere, then they each would be interfering with each other.